Good morning, everyone. It's great to see you here on this kind of mixed bag of weather here on Tuesday, May the 20th. And before we get started, we just always appreciate it when folks will share their name, update that in the participant list so we know where you're coming from. And it also helps me, Colette Bartow, the continuing education coordinator at the State Library, to make sure that we're getting credits applied to your continuing ed record. So thanks so much for doing that. We are going to be hearing from our esteemed speaker, Kris Goss, in just a moment. And I also wanted to acknowledge that our programs are supported by the dollars from the Library Services and Technology Act that are funded by the Institute of Museum and Library Services. And so with that, I do want to make sure that we have plenty of time for our speaker to share on this really high interest and important topic, whether you are a library director, a library trustee. The legal and operational issues that we're all facing are kind of part of the foundational set of skills and knowledge that help us to smooth the way forward as we are thinking about challenges, but also, how we overcome and problem solve within the authority and within the kind of the guidelines that both Montana Code and the administrative rules provide for us. So Kris is the director of the Library Learning Hub at the Helena College, University of Montana. He serves as an attorney and works with the firm of Jackson, Murdo, and Grant, PC in Helena. Kris worked with the School Boards Association and also served as a law clerk in the chambers of the Honorable Sam E. Haddon in the United States District Court for the District of Montana. Prior to law school, Kris worked as the governor's K-12 education policy advisor and deputy communications director in the administration of Governor Judy Martz. Kris brings this incredible wealth of experience in education, in libraries, and as an attorney. And so we are so fortunate to have his expertise and his willingness to share what he has to share with us in so many venues. So some of you may have seen and met Kris in other webinars and at the Montana Library Association. He does serve as the chair, or serves on the Library Association Intellectual Freedom and Government Affairs Committee. So, you will have multiple ways to be able to engage with Kris, and he has a lot to share. So with that, I am going to stop sharing and turn this over to Kris.
Thank you, Colette. That's a nice introduction. I always somewhat surprised when I hear it out loud that I've been able to be fortunate enough to do all of those different things and take these different career paths. And it's my honor to be a part of this library community. You've all been so welcoming since I made the decision to go back to school 2021 to the University of Wisconsin to secure a master's in library information studies. And when I completed that degree, I knew there was an opportunity to serve the Montana library community and libraries in particular. And each of you work with each of you as library leaders and advocate for our right to access information throughout Montana. So it's my pleasure to work with all of you and to share some of my experience in these areas. And as we work on all of these issues, just please know if you have any questions, any thoughts or perspectives on any of these items, just drop them in the chat. We'll be able to talk about them as they come up. We have an hour to cover some very important topics, and I always like to start with what are we trying to do? What are we trying to achieve here? And it's what I hope maybe is a reassurance to most of you that what you're doing is correct. It's on the right path. It's legally compliant, and that you then develop the confidence to respond to questions that you might get or inquiries that you might receive about your operations and their compliance with the law, with the foundation of knowledge that you have built up and that I'm seeking to reassure you about. If there's something new that comes up or something that is a little different than what your practices may be or what your understanding may have been, it's not that your perspective or understanding or process is wrong. It may be based in a different interpretation of the law, different application of the law based on your specific circumstances, and we'll work through that to identify any gaps in legal coverage or any challenges or opportunities for improvement. And so that's what our hope is: reassurance and confidence as we work through each of these different topics. I want to start with the Montana Constitution because it's I find it to be reassuring in times of uncertainty or in times of um, challenge when we look to what our Constitutional Convention delegates put together over 50 years ago and the voters approved. We know that it's a groundbreaking document. It's a document that many states and many citizens in other states are envious of. And one of those provisions is Article 10, Section 1, the educational goals and duties, the goals of the people of the state of Montana, that each Montanan, each person, it's not every, it's each. And so each person has a right to an educational system that is going to help them reach their full educational potential. And that's a pretty audacious goal. Each person's personalized right to an education to help them reach their individual potential, and that each person has equal access to each of those educational opportunities. But it's not that it's just K through 12 education. The framers, the delegates specifically included other aspects to education, including public libraries. And there was an attempt on the floor of the Constitutional Convention late in the spring of 1972 to remove the provision about public libraries and to say public libraries aren't really a part of the educational function that we're envisioning here. Is this truly about just K-12 education, higher education? And the Constitutional Convention delegates rejected that attempt to remove public libraries from this constitutional provision. And what I think that does is express the delegates' wishes, express the delegates' desire to have public libraries serve as the next phase in everyone's right to education and to reach their full educational potential. Your educational pursuits, each Montanan's educational pursuits do not stop when they graduate high school or when they graduate college or complete their certificate at an institution of higher education. Rather, the public library is established by the legislature consistent with this constitutional provision to ensure that every Montanan's lifelong learning pursuits are honored. And so the public library is the graduate, postgraduate level institution in each community where people can access information. And I like to think about that provision. We've posted a copy here at the Helena College Library Learning Hub to remind everyone about our role for both our students as well as our community patrons, that this is a public library that's intended to help everyone reach their full educational potential. And I'd be remiss if I didn't discuss subsection 2. The state recognizes the distinct and unique cultural heritage of American Indian peoples and is committed to educational goals, the preservation of that cultural integrity. And that's embedded in every Montanan's right to an education, is to learn about the unique cultural heritage of our American Indian citizens, neighbors, and every one of us in a library or school or institution of higher education has an obligation to learn and help others learn about that as well. And so this provision and its 3 subsections really work together to capture, I think, what we're doing and the work that libraries do in a public setting, academic setting, public school setting, and we all work together to reach those goals. So just a little bit of reassurance about your work, and starting on a positive note as to how our state's constitution and its unique provisions help guide us in our daily business. We also then want to look at another aspect of our state's constitution, and it's Article 7, or Section 7 of Article 2 of our state constitution, and it reflects the U.S. Constitution, the First Amendment to the U.S. Constitution, which we're all familiar with. And you can look at that provision in the U.S. Constitution and see that it contains quite a few different clauses. No law respecting the establishment of religion, prohibiting the free exercise of someone's religion, abridging the freedom of speech or of the press, the right of the people to peacefully assemble, and then finally, the right of the people to petition the government for redress of grievances. That's quite a few provisions in that First Amendment, and they all capture the spirit of what each American knows, that I have a right to worship or not worship without government interference. I have a right to speak about my opinions on specific topics. I have a right to print specific opinions on certain topics. I have a right to gather. I have a right to assemble and discuss these issues. And I have a right to tell the government that I think it's wrong, and that you as the government or as agency of the government have an obligation to hear my petition and consider fixing what I've identified to be wrong in government operations. And the state constitution reflects that. It has one provision about consequences for abuse of the right to free speech, which we have to keep in mind, that you may speak your opinion, but there's also the potential for consequences when that happens. And so these constitutional foundations provide us with a framework of how to consider library operations, because the First Amendment to the U.S. Constitution has been interpreted not just about speech and writing, but also the ability to receive speech, to receive information, to receive the written word. And those are based on some cases, early part or mid part of the 20th century, where the Supreme Court of the United States ruled that there is a right to receive information, that there is a right to have someone explain something to you or to provide their perspective to you. And if you want to receive that perspective as a citizen, that's embedded within your First Amendment right. In that case, in Martin versus Struthers, the court ruled that a city ordinance preventing people from going door to door passing out pamphlets was a violation of the First Amendment. Now, you don't have to accept that information as a homeowner or someone living in a dwelling, but you certainly, the city or the municipality can't prevent someone from trying to offer that information to you. And whether you accept it is up to you as a citizen. If you choose to accept it, that's up to you. It's not up to the government to prevent it from occurring. It was also confirmed then in Griswold versus Connecticut, a case you might be familiar with regard to issues of reproductive rights. But it was about the state law that prevented distribution of information about contraception that was in part ruled to be unconstitutional, because it was restricting the right of citizens to receive information on that topic if they were seeking it. And so prosecution of doctors distributing that information, or restriction on the rights of doctors to receive that information, and restriction on the rights of citizens to receive that information is improper in interpreting the First Amendment to the Constitution. So we have this right to access information, and you see the concept of a barren marketplace of ideas if there were only sellers and no buyers, which is a great way to put it. If you just have people talking and just have people writing consistent with the First Amendment, and then they're just shouting into the void, does that really matter? Or does there have to be someone who's willing to listen to them and read what they've written? That's the next step, and the next interpretation of the First Amendment is the right to receive information. And so when you receive information and you have that right to receive information, the compilation of that information, the repository for that information naturally is going to be the public library. And the library history and tradition that we have in the United States is a natural extension of that right to receive information. And in the Third Circuit case in the early 90s, and Crimer versus Police Bureau, or Bureau of Police, you had the ruling that there is an expectation that the library be the place where people can exercise their right to access information. And in that case, which we'll talk about as it applies to patron conduct in a little bit, you have the place, the natural place for people to receive information being the library. And that court case confirmed that. And it has been that interpretation um, throughout the late 70s and to the current time, that is the place where people can access information. They are the quintessential public forum to access information. But there may be restrictions on how that information is accessed, and we'll talk about how that applies in certain situations for the rest of the hour. So we have that right to receive information. The public library is the place where information naturally can be accessed. How does that apply then to public libraries and school libraries? In school libraries, as this case law was developing, you had a situation develop in the Island Trees Union Free School District, where the Board of Trustees in that school district determined that that there were books in the school library that were unpatriotic, that discussed ideologies like communism and Marxism, and that the library shouldn't have those books. The school library shouldn't have those books. And so one of the students in that situation in the late 70s, a student by the last name of Pico, and other students challenged that decision by the Board of Trustees. And what we saw emerge from that controversy was a plurality decision stating that the right to access information extends to minors, and it extends to minors through the school library, that the school library is a voluntary setting where students can access information that may support the curriculum, but it's not required that they access that information or access those materials as part of the school library. And if they do access it, it's their choice to do so. If materials are placed within a school library, consistent with a policy that's been developed by the Board of Trustees, and that collection is developed to spur and encourage reading, critical thinking skills, and concepts of citizenship, as well as in support of the curriculum, then those books are deemed to be appropriate for placement in the curriculum. To remove something from that collection would have to be completed in accordance with a reconsideration process where the material is found to no longer meet the collection policy. Simply removing materials from a school library because of the viewpoint expressed within those materials deprives the students of their right to access information and violates their First Amendment rights. And so that's an emerging concept that you can see coming in the late 70s based on those other rights to access information in the cases that were handed down in the mid part of the century. And as a result, you started to see the development of the right to access information, and it be applied not just to adults in a public library setting, but also to minors in a school library setting. And so that led to some other discussions in about how libraries and public libraries in particular should be managing their collection. And we see those discussions occurring through the current court, and we can likely expect a decision on this topic and how it relates to patrons and parents' rights to their faith, and how that interacts with the public's right to access information, individual citizens' right to access information. So some of this information may change at the conclusion of the current court's term, but as we understand it now, the public library's collection is going to be based on that right to receive information. The case law, as it's evolved, consistent with the First Amendment, that when items are identified for placement in a public library collection, they are done so in a way that's consistent with that collection development policy, but also with the right to access information of the individual patrons, as well as applicable state laws governing distribution of information and materials. And that often settles on the issue of obscenity. And we see and have seen discussion of that obscenity law, Montana Code Annotated Section 45-8-205, which is itself based on the United States Supreme Court decision in Miller versus California, where in determining whether something is obscene, it has to be taken in its entirety. The entire item, the entire book has to be reviewed in a manner that can be considered on its whole, on the whole, not just one segment or one piece or one scene or one chapter or page or sentence. And upon that review, there is a determination as to whether or not that item, that book, that piece of material in the collection is not appealing to the purient interest of sex based on the community's standards, that it not have offensive conduct defined in applicable state law, and that it has serious literary, artistic, political, or scientific value. And that's an important phrase in factor 3, where you have an expectation that material shows some value, that it has has value related to the arts, has value related to literary pursuits, related to science or philosophy or political thought. That is itself embedded in the concept of preserving viewpoints and respecting viewpoints and allowing viewpoints to be exchanged in a way that's consistent with people's right to speak, but also consistent with others' right to receive and hear information and engage in discussion within that marketplace of ideas that we've heard. So that third factor is very important. And in a different Supreme Court decision a few years later, they developed what's referred to as a reasonable person standard. That doesn't typically vary from community to community. It's going to be reviewed on a reasonable person standard in terms of whether there is a prurient interest in sex, or whether this does engage in offensive conduct. And the offensive conduct itself has been defined through case law with regard to harmful conduct towards minors that is depicted in those types of illegal depictions of minors for purposes of sexual gratification, or whether you have conduct depicted that is of an unsafe manner or encouraging unsafe behavior, or maybe encouraging or participating in discriminatory conduct. And that can vary from a school library to a public library, but this issue of obscenity is always going to be one that's grappled with in the courts and in communities around the United States. And we've seen this test applied consistently in the 50 years since it was developed to allow for the exchange of ideas and allow people to receive information. And that's some of the case law that we'll discuss in the subsequent slides. But it's important to remember that there's also a provision in Montana law which authorizes local governments to adopt ordinances or policies that may be more restrictive than the standard set in 45-8205. And so making sure that that's monitored on a local level and determining how that would apply to a public library or school library's operation is important. But having that understanding and the ability to identify that this may be sex related, but it is not appealing to the purient interest of sex. It may have a content that is related to these topics, but it is not a violation of the standards or the statute, because it does pose and provide serious literary, artistic, political, or scientific value, even if some may consider it to be offensive. And so that application of the test will be important. And I think as you develop or revisit your collection development policies or plan, having an understanding of the Miller test, having that phrase about serious literary, artistic, political, and scientific value embedded into the policy, it can help make sure you comply with the obscenity standards and are able to faithfully respond to inquiries about how the collection development process occurs within the library through the court decisions as well as the state law. A similar concept is not just about removing items from a library, but removing them from general circulation and replacing them in what sometimes is referred to as a restricted access area. And the concept of a restricted access area is one that courts have reviewed and handled in a similar way of just removing books from the library's collection in their entirety. And having an item placed in a restricted access area has been viewed in both school libraries and public libraries as being an improper act under the standard interpretation of the First Amendment. In a school setting, and it happens to be both of the cases I've highlighted here in Arkansas, in Counts versus Cedarville, you had a situation where a board of trustees did not want the school library to have the Harry Potter books in their collection because of concerns about witchcraft in the school. There was a challenge to that decision, and it was found that that decision to remove those books had not followed the proper reconsideration procedure, and it amounted to viewpoint discrimination, that it was solely on the basis of the content of the books, and that content itself did not rise to the level of being harmful to the minors. It was not a violation of the Miller test, and as a result, the students in that school had seen their First Amendment rights violated because the right to access information was disrupted by having those books placed in a restricted area of the school's library. Same concept recently applied based on a statute developed by the Arkansas legislature, where the implementation of the statute was found to be unconstitutional because it required a determination of the appropriateness of the library material for placement in the general collection that was available and accessible to all patrons in the public library setting. And so having something that was deemed to not satisfy the appropriateness standard as outlined in the law and placing that material in a section that was, quote, and required by law to be inaccessible to minors did create an interference in patrons' rights to receive information. And so the question often becomes, well, how does that apply in a real world situation with regard to a school library or a public library and the layout of our library? And it's not saying that the library shouldn't be organized by reading level or shouldn't be organized by content or by subject or by the grades of a particular school that are served. Instead, it's making sure that the library is free, open to all, and accessible to all. And you're relying on the librarian, specifically a school librarian, to help the students find something of their reading level, but also assisting any patron in a public library with finding information that they may be interested in. If something is in the general collection of the public library, it's been deemed to satisfy the collection standards that have been developed by the library board and interpreted by the library staff, developed in consultation with the library director. And so having that collection that satisfies that policy organized in a way that says this is the children's section, this is the teen section, this is the biographies. This is the nonfiction. This is the romance section. This is the popular fiction section. Having that layout is not improper. It's making sure that the full layout is accessible to any patron who may enter the library. And if it's a minor, then the librarian, the parent working together to help the minor reach the area that they may be interested in, consistent with the rights of parents to raise their children and consistent with the authority of the library staff to manage patrons and assist patrons consistent with their desires and rights. So that comes back then again to the library policy setting forth not just what's in the collection, but how the collection is laid out, so that it's unrestricted, but that it's managed and organized in a logical manner. So we've talked about the collection consistent with the First Amendment and the right to access information under the First Amendment. The facility itself also is governed by the First Amendment to the U.S. Constitution, and the library, public library especially, is a public forum. There are different types of public forums under the case law as analyzed by the courts around the country. You have a traditional public forum. That's the place where the marketplace of ideas is freely exchanged, consistent with any city ordinances and applicable state or federal laws. But it's typically the streets, the parks, the sidewalks, places where people can gather and assemble and exchange ideas. Typically at Helena, we see it happen at the Capitol. It may in your communities be in the courthouse, the lawn of the courthouse, or oftentimes in front of the library. So that sidewalk in front of the library is oftentimes considered a public forum. People still have to be able to access the library and have to be able to get in the front door, but there may be a peaceful assemblage of people that's not disruptive or restrictive that occurs in that traditional public forum. You have a limited or designated public forum is government property that has been established or opened for a certain expressive activity or for the receipt of information or the expression of opinion or information. That's the facility that can be reserved, the meeting rooms in the library, the library, the general library floor, the area of the library where people can access the collection. Those are limited public forums. Certain public forums may have different conduct expectations. You may have quiet areas, you may have active areas, you may have meeting rooms where that exchange of ideas can occur in a more general or less general sense, but more specific topic-based sense. And so that's the limited or designated public forum that we're going to discuss in a little more detail. Government property that is reserved for a specific function that doesn't necessarily relate to the exchange of ideas is a non-public forum. The director's office would be an example. It's not a place where you have an assemblage of people to exchange ideas or engage in discussion. Rather, it would be a government space where people are completing government work. And so disruption of that area may, again, be subject to a different policy and a set of standards under the city's ordinances or state's laws. That's all going to be determined by the policy. And you have factors within that policy that are going to outline what is the behavior expectation of the lawn of the library versus the library meetings room versus the floor of the general common area of the library versus the director's office. And having that policy clearly outline those and having then in turn the restrictions on the speech in different types of forums handled in a manner consistent with the First Amendment. The forum is going to dictate what is permitted. The forum is going to dictate how that conduct can be expected to occur and how it will relate to the other patrons' rights to access information, which is going to be like in the common area where the collection is held. A person engaging in disruptive behavior may interfere with someone else's right to access information. Loud conversation in a meeting room is going to be different than perhaps active conversation on the floor of the library. And so having those distinctions outlined in the policy will help with the defense of any library staff intervention in enforcement of that policy to ensure that each patron is able to access information consistent with their rights. What's important, and you've heard me mention it in previous slides, is that viewpoint discrimination, the viewpoint prohibition or restriction is not permitted. The same as with the development of the collection or the removal of items from the collection is not based on viewpoint. Restriction of access to the meeting rooms in the library is not going to be based on viewpoint, as we'll discuss in detail in the next slide. And so having those content neutral, viewpoint neutral implementation of the policy and enforcement of the policy, it can help make sure that if there is a need to restrict the access to the facility, or there's a need to deny access or prevent future access or to stop an event, that it's done so in a way that is permissible under the law and defensible due to the policy. And so when a library or a school is considered a designated or a limited public forum, the courts have ruled that it is there to ensure that it's not the sidewalk, it's not the lawn or the steps of the Capitol or the lawn of the courthouse. It's a place inside the building is where this exchange of ideas can occur, and that assembly is there to engage in an activity or engage in expressive conduct in a public place. It's a location that the state has said this is where we can encourage communities to gather and discuss ideas. It's there for citizens, any citizen, each citizen, to engage in that type of discussion and allow others to participate, even if their perspectives might be different. And so when that forum is created, it is an action of the government intended to ensure communities' strength through its promotion of community events and in discussion of particular topics. But the policy is going to lay out how that occurs. It's going to lay out how the room can be reserved. It's going to lay out the expectations of conduct in a particular portion of the library or a particular part of the library's grounds. And it's going to outline any technology or access to additional resources that the library may provide. It's going to detail the conduct that's expected of those participating, and it will outline the role of the staff in completion of that event. And when all of that occurs, and it occurs in a clearly written manner that's objective, that is content neutral, that does not discriminate on the basis of viewpoint, then you have a policy that achieves the purpose of the designated public forum, which you have as a place for people to gather and engage in activities or engage in discussion. And that not just reasserts the relevancy of the library and reasserts the role of the library in the community as a gathering place, but it helps the community get better by having that location where people can get together and engage in that type of discussion. So there's always questions that come with this issue, and I've encountered those, and I've just developed a slide to address them head on. Does this type of forum permit faith-based groups to engage in their worship or their instruction or their discussion of their faith? And it does. We've seen the evolution of the Establishment Clause of the First Amendment, that provision right at the beginning about the free exercise of religion and the government making no determination on the requirement or the no determination on the imposition of a particular faith. And so the question has always been, if you have faith-based activity in a public setting, is that an endorsement of that faith? Is that an entanglement between the government and that faith? And the courts have evolved to say, no, it's not. It's the same interpretation as you would apply to the 4-H using the library meeting room as you would for this faith-based group engaging in the use of the room. It's not an entanglement. It's permitting that use in a similar manner without restriction based on viewpoint. And so that's been an evolution. You recently saw as it applies to public employees at public places. And so I think it's fairly common for those faith-based groups around the state to utilize public spaces consistent with the First Amendment and the interpretation that it's not an entanglement because it's the same access others may have. Political and ideological use, a similar question. Does that mean that that can be considered an endorsement of a particular candidate or party or committee or ideology? No, it's that group utilizing a designated public forum consistent with the policy in the library permitting that use, consistent with their expectations and obligations to not engage in viewpoint discrimination. That's all permitted. You saw that same case that we just talked about in Cornelius and NAACP, that same confirmation that ideology and restriction of access based on ideology is itself viewpoint discrimination. But there's a wrinkle here that's important, and it's how the library staff is involved in the particular event. And caution in this area, I think, is important because if someone is on the clock working as a library staff member and they're engaged in support of that particular event or by extension that group, that candidate, then there could be confusion about the library's role in that event. Or in the worst case scenario, there could be a claim that somehow the library itself has misused public funds in support of a particular group, entity, candidate, committee in matters of politics, political races or campaigns. Having an entity host an event at the library is entirely appropriate. Often as the League of Women Voters engage in that type of candidate forum. Is the library the one that should be filming the event and posting it on the library's website? Or is that something that should be filmed by the hosting the event and posted on their website? I think there's a valid concern and a need for caution in that area to ensure that the library doesn't get unnecessarily entangled with political events while the library staff are being paid with public funds. And so caution in that area is important with regard to the faith-based events that might be happening in the library. We've seen the Supreme Court rule that when a public educator or a public school employee is off the clock and no longer being paid, that they can engage in faith-based speech, even while at the school in which they're employed. But that's the distinction of when they're on the clock, so to speak, and not off duty, that's important. And so the library staff, beyond just facilitation of providing the room, facilitation of the reservation process and policy, and discussion with the organizing group about the arrangement of the room and technology or other services that are necessary, are all within the library's operations and not completed in a viewpoint neutral manner, that next step of actually engaging in assistance with the event, it can be an area of concern that the courts haven't quite resolved yet. And so it's one that we want to be and just urge there's some caution on when handling it and dealing with those types of events and meeting room use. The conduct and behavior expectations with regard to a forum, a limited forum, on the floor of the library, or even when a group has reserved a room, are important. We have a number of court decisions that said that the library has the authority to establish those reasonable ground rules for using the library. The rules have to be related to the purpose of the library, and the purpose of that library is to honor the rights of citizens to access information under the free speech laws. And so interference with other patrons' rights could be the basis for regulation. And utilizing a library's power to regulate the patrons' behavior can be reused, can be based on safety expectations, managing managing resources in an equitable way, making sure that the area is clean, hygienic, secure. All of those are reasonable expectations for a library to utilize its authority in a rationally related manner consistent with its mission. And so when you have those questions come up, utilizing a patron conduct policy that is soundly written, facilities use policy that is soundly written, based in that concept of honoring people's rights to engage in exchange of information, access to information, and engage in free speech, will help make sure that the policy is not only compliant, but defensible. And so that leads us, you've heard me say the word policy probably on every slide. That question of policy is important. And we have statutes that specifically authorize it, 22-1309 for those free public libraries, adopt the bylaws and rules for the government of the library not inconsistent with the law. For those library districts, that you have a similar provision that can help guide the operations of the library in coordination with the county commission in some cases. School libraries have similar policies. Boards of trustees adopt policies for the operation of the school consistent with Title 20, Section 20-7, 203. Trustees adopt the policies necessary for regulating the use and operation of the school library. So you have that legal authority as a library board, director, staff to develop and have those policies adopted, so long as they're not inconsistent with the law. The library's policy is always going to be the first line of defense in litigation, threat of litigation, challenge, or question. Just even a simple exchange with a patron, you're able to point to the policy and say, we have this policy because it helps us maintain continuity, maintain consistency, regardless of who's on the board, regardless of who the director is, or regardless who's working the desk that afternoon. We have a policy that helps make sure that everyone's right to access information under our U.S. Constitution is honored. And everyone has a right to be in the library, utilize the library in a manner that is envisioned by state law. That we're able to ensure we have a division of labor between board and staff, between management and staff, and that we ensure that the administration of this library is handled in a legitimate and legally compliant manner. And you're able to manage things more efficiently because you have a policy that guides situations. You don't have to recreate the wheel in every situation. You have a policy that generally governs, that's written in a way that's compliant with the law, but also reflective of the community's expectations, while also being flexible enough to apply to a variety of situations. And when that happens, then you have a policy that's workable and a policy that can help maintain that stability. It can come from statute, can come from state regulation, judicial opinion, your established practice, the recommendations from local government or the county attorney or the insurance carrier, the philosophy of the board, and the interaction with the staff. Do we need to adjust this based on um, recent issues that have emerged in the library? All of that can occur through that collaborative discussion and the expectation that your library board meetings are open to the public, and um, that transparent and accountable operation helps receive ideas from staff, receive ideas from patrons, receive ideas from those that have them, and you're able to take those into account when developing policy. You also may have financial management policies that are required based on your auditing expectations. Any policy in a library should be based on not only the law, but also your policy on policies. And it seems redundant, but it is necessary. That policy on policies will talk about how policy is reviewed, adopted, revised, terminated, deleted. You may have a bylaws or a memorandum of agreement with other government agencies or entities. You may have other governance documents. That should all relate back, and they should be consistent with your policy on policies. And that authority then of the board to engage in the development of a policy through the open meeting law, through committee work, through collaboration with staff and administration in helping develop a policy that's workable for the library. And when you have that policy then completed, it should be accessible. Everyone should be able to read it. Everyone should be able to access it through the website, through hard copy at the library. Having that policy accessible helps make sure people understand it, but also it helps make sure that it's an active document, that it's always in people's minds, and that you're reviewing it regularly, consistent with the library standards, but also to help make sure it's consistent with your practices. If you do have employee handbooks, collective bargaining agreements, or other governance documents for personnel, they should also be reflective and consistent with your policies. So that the policies, you don't have a question come up of to, well, what governs here, the policy or the handbook and the bargaining agreement. Always making sure that you have that thorough review and anticipating all of those different issues that can come up, and having a policy that's nimble enough to allow you to achieve the goal of efficient operations. Many topics, but these are some standard ones that I've taken questions on and assisted people with. And want to have those in place based on the laws that we've discussed, but also your community's expectations and practices. One that I think I've seen come up more frequently in the last couple of months is those policies on volunteers, and having that volunteer policy in place is going to be important. That you have an expectation for the volunteers, you have a volunteer agreement form, and that you have that regularly reviewed with your insurance carriers on both workers' compensation and liability insurance to help make sure that your volunteers are covered, and that the library is covered, and that you are able to utilize those volunteers to their fullest extent. But all the other topics that we've discussed with regard to patron conduct, collection and reconsideration, the meeting rooms, your displays that you might have, how you handle gifts and donations, how you handle non-discriminatory requirements under state and federal law. Having all of that in place, it can help reassure the public that their library is working in an efficient and appropriate manner. Before we get to questions, just want to talk about the Library Assistance Helpline. This is a project of the Montana Library Association that I'm participating in and working on. If you send an email to helpline@mtlib.org, that'll come into my phone, and I'll reply or set up a call, and we can talk about any issues that you might have, and I can direct you to the appropriate place, the partners that we have through the state library, and the relationships we have with other attorneys around the state, or the knowledge that I have that we can share other librarians, information professionals, where we're able to identify and help get you the information that you need to make an informed decision on the topic that's facing your community or your library on library operations. So you can stay focused on learning the library and doing so in a legally compliant manner. Well, have there been any questions that have come in?
Um, the only questions really have been about whether people will have access to the resources that you've been sharing. And I said yes. And we'll be sharing some of the resources as well as the recording in, on our YouTube channel and through the Aspen event. I included links to those in the chat so far. But I am very curious if there are any questions or any particular situations that folks have questions. This is your time. We have just a few minutes left, but please don't hesitate to ask Kris. We have both the audience and we have the captive expert with us.
And I understand if you don't want to put it on the recording, you send an email. We can set up a call to talk one-on-one and get the information. If you do send an email, it'll likely be after hours or in the lunch hour when I get back to you. But it's I've heard that it's nice to have people just to know that there is a place that you can send questions and get some guidance or be pointed in the right direction. And I've found that there are a lot of experts around the state. I bring a unique perspective on these topics, but I also know that to just be mindful of the other partners, what they can do. So my goal is we all want to work together to help make sure our libraries are working appropriately and compliant with the law, and that they're defended against anyone attempting to assert otherwise. And so we all collaborate and work together on those goals.
That I think what you said is really important, and it relates to the question that just came through, consistency with the law and not exposing boards and libraries to liability. So the question is about what are potential problem areas for volunteers that you've been asked about or that people should be aware of?
Sure, and volunteers are critical to every library's operation and most schools' operations. They have a role, and it's important for them the areas to be addressed in the policy, that the volunteer does or does not have access to patron information. If they do have access to patron information, what training have they completed in order to gain that access? And what expectations are they then reminded of through that training about the patron confidentiality laws in Montana? And what interaction do they have with minors in the library setting? If they have that expectation or that duty, do they have to complete a criminal background check? And if so, then how does the library's insurance carrier work to monitor that, and how frequently would that check have to occur? They're always supervised by the library staff and confirm that they, through their volunteer agreement, that they would honor the directives of the library staff. They'll honor all library policies. You have those types of things written into your policy and then reflected on the volunteer agreement form. Then when someone does violate those terms or violates the policy or any other policy in the library, then their term of service as a volunteer could be rescinded or terminated. And so those are the types of things that you want to take into account. What do we need the library? What kind of volunteer service do we need in the library, and how can we craft a policy consistent with our insurance coverage to have that completed? Does the county or the city already have a volunteer policy that we need to review and work through? How do we interact with the volunteer when they're quote on the job or not on the job when they're visiting the library as a patron and not serving as a volunteer? Distinguishing between those types of things how to have all of that in place and in a policy and reflected on a volunteer agreement form is important. I see another question come in. Privacy of staff member override the public's right to know. Um, that's one that we could probably spend another hour on. But there is the concept of public trust. When the trust of a public official, public employee, there's public's trust in that employee has been violated. Typically, that can come in the misappropriation of public resources or the misuse of public funds or engagement of conduct that, while on the job, has is of a criminal nature or is a violation of some policy um, or other aspect of the operation of that public agency. And you've seen that apply. If you think back to different news articles and case law, public employees do have a right of privacy in their discipline and evaluation and employment files. But if they step outside of the public's trust, engage in that type of misuse of resources or other type of potential misconduct that the public has a right to know about, then the right of the public to know under the Montana Constitution can exceed the right of privacy that's contained in the same article, Article 2 of our Montana Constitution. So the courts have to constantly balance those. And if you have a public meeting under the open meeting law, there's an exception to the open meeting law for closed sessions on matters of privacy. But is there a right of privacy on something that is where the public's right to know exceeds that right to privacy, and that would be held in open session? So the question of the public's right to know um, may be different than the trustees' right to know, in that the library board may have a closed session to discuss that incident with the employee who may have been involved or the patron who may have been involved present. We don't want to get too far into the open meeting law here because it could take forever, but handling that issue in a way that the trustees know about the operations of the library consistent with their role as a member of that governing board may be different than the public's right to know, so long as the trustees, if they are accessing private information, know that it can't be disclosed to the public. So if you wanted to talk about that in a little bit more detail, you could send an email and we would be able to discuss it as needed to get the full set of facts and apply the law as we know it.
Thanks, Kris. I think that's really helpful. It really highlights what you've been talking about, is that consistency with the law, understanding both the rights and the kind of the processes that are really important so that everyone is well within their rights and well within their authority to either act or to clarify a situation. And we definitely want to follow up. Kris and I talked a little bit about doing some additional webinars on doing a little bit deeper dive on some of the topics that have come up in these questions. So look on the Aspen event calendar and in upcoming continuing education newsletters for announcements of those as we get those developed and pinned onto the calendar. Kris, I can't tell you how much we appreciate your time today and your expertise, your generosity in providing, that lifeline through the helpline to kind of piece through some of these tricky situations. We always welcome your feedback. Those of you who are participating today, if you wouldn't mind just giving your comments in the State Library evaluation form, and just know that I'll be tracking your credits and just approving everybody's attendance today who pre-registered for the session. Do look for the recording either later today or first thing tomorrow morning. But Kris, again, thank you so much for sharing your time with us and your expertise. It is invaluable to us.
Thank you. It's my pleasure. I appreciate the opportunity to work with all of you. So keep in touch and we'll be ready to help however we can.
Sounds great.